Good afternoon and welcome to the University of Tulsa College of Law's first in a series of 6 showcase presentations that we'll be having this academic year. We hope that you will enjoy this presentation and come back for the other 5. They say there's no free lunch anywhere, but there is here, right? And in addition, you're getting an hour of credit for CLE each time that you come to the showcase series. Today, it's my distinct privilege to introduce my colleague and friend, Professor Tamara Piety. Professor Piety was an honors graduate of the University of Miami School of Law. She has her Master of Laws from Harvard. She has taught at Stanford, at University of Missouri, at Florida State, and she is one of our own. Has been here long enough now that she considers Tulsa a home, which is great for us. Since 2001, Professor Piety has written a series of articles in the area of commercial speech, culminating in her latest article, which you have the abstract from when you picked up today, Citizens United and the Threat to the Regulatory State. She's been in the vanguard in this area and was somewhat of a person kind of expressing an outlier view at one time, but more and more people have had opportunities to see the direction that the country is heading with respect to more and more aggregation of corporate power and exercising rights many people think should belong only to natural human beings. And she's been in the forefront of warning of the perils of this, and more people, thanks to her writing and work in this area, have begun to catch on. So a lot of this culminates in the Citizens United case from the last term. I followed that case primarily as a politically involved individual, worried about whether that would tip the balance too much in the corporate direction in the political environment, but Professor Piety saw other things which I believe all need to be worried about. If you liked the idea of Lochner, none of us were alive when that case was rattling around, that prevented progressive legislation or just even moderate legislation on the fronts of health and safety and economic regulation from the federal to the state levels. There's things in Citizens United, as Professor Piety will point out, that threatens to turn the First Amendment free speech clauses into a Lochnerian device for corporate power ends. And so without further ado, I want her to have plenty of time to address this topic with you today. My friend, Tamara Piety.
Thank you, Gary, and thank you all for coming. And I'm really happy to have this chance to talk about this case again. I've been talking about it. I did something similar, a similar presentation before the decision at the Federal Trade Commission, and I talked about it at Hastings and some other places. So now I'm going to do it again here. This is a little bit, perhaps, of a bait and switch, because if you thought we were going to talk about the election aspects of Citizens United, we're not. There are a lot of things that we can talk about with Citizens United, and I'll just touch a little bit on some of them. But let's just first kind of review the facts if you weren't familiar with them. Citizens United was a nonprofit political organization. It produced this movie, Hillary, the movie, cue, dun, 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 some really bad things might happen to the country if we elect Hillary Clinton. The organization wanted to distribute this movie on pay-per-view, and it wanted to do so in a time period that might be prohibited under the Bipartisan Campaign Reform Act, also better known as McCain-Feingold. And it sought a declaratory judgment seeking the ability to be able to do that without violating the law and, among other things, to declare it unconstitutional, although that provision was scrapped from their case. The court held, and this is just a very simplified version of part of what they held, but the main thrust of the holding was that the Bipartisan Campaign Reform Act's provision that prohibited corporations from spending money from their general treasury on electioneering speech that expressly advocated the election or defeat of a candidate in connection with certain qualified federal elections within 30 days of a primary or 60 days of a general election was unconstitutional, and it moreover overruled some precedent from the 90s, Austin versus Michigan Chamber of Commerce and FEC versus McConnell in whole or in part. Well, that's the political election part, and that's the thing that it is probably most famous for or infamous for. Election law is really complicated. All those terms are terms of art, electioneering, what's electioneering, so forth. It is not, despite a lot of the criticism of the opinion in some circles, the kind of sweeping, anything goes entree for corporate money into campaigns, as some critics suggest. It's not clear that it's going to have that much effect on corporate campaigning because, as the Target fiasco with this candidate Tom Emmer, the sort of anti-gay rights candidate in Minnesota, that Target wanted to funnel a little bit of money to his campaign, and it like exploded in a national issue. Target immediately backtracked and tried to win back its customers who were wanting to boycott them. So I think that's not going to be something that we're going to see a lot of ExxonMobil endorsing this candidate or another. What we're going to see more of is AstroTurf, which they could already do. And AstroTurf, if you're not familiar with the term, refers to those kinds of political nonprofit organizations that are set up in somebody's PR firm's offices, where they go and they get, file pictures and they put together some stuff, and it's like Working Families for Walmart or whatever, and it looks like there's this grassroots organization for something or other political. That's probably what they're going to keep doing because it sort of it obscures the source. Its most immediate effect, salutary effect, if you think this is a good thing, might be on the election of judges. As you may be aware, Justice O'Connor is one of those in the forefront of arguing that judicial elections compromise the objectivity of judges, and this case, in conjunction with, interestingly enough, a decision that is in some tension with Citizens United, the Caperton versus Massey Cole decision, may provide the impetus for a lot of states to get rid of judicial elections. And, we're not going to talk about that now. There's a lot of remedies on the table. Fair Elections Now Act, some constitutional amendments that are being proposed. This seems to be the year for constitutional amendment proposals. Let's do away with the 14th Amendment. I would urge those who think that that's a good idea that just remember this: the 14th Amendment that was the vehicle for declaring corporate personhood. So we might want to rethink that if you think that's good. And judicial activism. I think in my view, one of the best outcomes of this case, aside from giving me lots of stuff to talk and write about forever, it's like really self-interested there. I mean, I obviously oppose this decision, but the bright side, the silver lining, is that I get to talk about it. Judicial activism, I hope now, is going to be removed forever from the lexicon of a pejorative term that applies only to the left, since Part 2 of Kennedy's majority opinion consists primarily of saying why it is that we cannot do what the parties would like us to do. And I emphasize here parties, not just one side or another. They offered a lot of arguments, and what were those arguments? Citizens United argued these things. That this was not an electioneering communication, that it wasn't publicly distributed because it was on cable, that the case law does not support an application to this case because it's not express advocacy, it was just a documentary. That pursuant to Austin et al., the case law suggested that you could carve out an exception to McCain-Feingold for nonprofits. And here we have the parties in agreement because the government chimes in, yeah, we think that's kind of a good idea. That the facial challenge to the constitutionality of the statute was not before the court because Citizens United had stipulated to its dismissal in the lower court. So pursuant to some of those, axioms about how you shouldn't decide constitutional issues if you have any way to avoid it, was not invoked here. This is, again, in addition to the prior precedent that it overruled. So what was the important principle? The right of corporations to freedom of political expression under the First Amendment. This court has rejected the argument that political speech of corporations or other associations should be treated differently under the First Amendment simply because such associations are not natural persons. And remember, it wasn't necessary to go that far because you could just have said nonprofits. So the issue today, well, let me back up for a moment. That statement about the necessary and the sort of obviousness of corporate political participation was actually not at all obvious prior to 1978 and maybe 1976. It was, I submit, the development of a little-known doctrine called the commercial speech doctrine that is perhaps responsible for the Piety decision, which the court in Citizens United wanted to hearken back to. It wanted to return to the Piety decision and the strong statement of corporate participation in the electoral area. And not everybody knows what the commercial speech doctrine is. I had let me go back here for a minute. I had a friend, I was talking to a colleague at Illinois, and she says, Tamara, you are becoming one of the leading experts on the commercial speech doctrine. Well, that would be great if anybody knew what that was. Commercial speech doctrine, what is that? But what you see in that quote, and let me just go back for a minute, this sort of rejection of the argument that political speech of corporations or associations should be treated differently is what seems to be an argument of somehow invidious discrimination, that treating corporations differently under the First Amendment is somehow invidious discrimination, it's prohibited kind of discrimination under the First Amendment. The court notes that wealthy individuals are not limited by that same provision of the McCain-Feingold, and that lobbying may still take place, yet certain disfavored associations of citizens. This disfavored association of citizens, i.e. corporations, those that have taken on the corporate form are penalized for engaging in the same political speech. So let's start back for what I say is the kind of genesis of the connection between commercial speech and this corporate speech and why I think it's sort of problematic. And I will say, kind of give you the touch of the chase that is so cleverly hidden in the title of the piece that you received with this lecture, which is that the rhetoric in the Citizens United case is likely to provide a lot of ammunition to those who would like to extend full First Amendment protection to commercial speech. And if they do, if we extend full protection to commercial speech, what you then have is arguably and potentially a threat to almost everything that we think of as kind of conventional regulation that has been relatively uncontroversial since the New Deal. So, securities regulation, financial, the new bill that was passed regulating the financial industry, including credit cards, what you can say in terms of selling certain things. And, any number of other things, and I'll talk about that again at the end. But we should start with the proposition or with the observation that for about 200 years, the First Amendment was not thought to cover commercial speech at all. Nobody thought that the First Amendment was something that was a subject of commercial activity. And indeed, there are some people who would say, now actually let me back up for a moment, because there are some people that say that there was coverage, we just didn't have any cases on it, and historians who say, look, at the time of the framers, advertising was a big part of it, but there was no explicit statement that it was covered, and indeed their litigation under the First Amendment didn't really start till the 19th century. And, late 19th century, early 20th century is where we saw really almost all of the classic First Amendment cases that now form part of the doctrinal analysis. And when it came up in 1942, in this Valentine versus Christensen case, the court just kind of gave it the back of the hand. Mr. Christensen was a guy who had a submarine that he wanted to choose. He wanted to charge a fee for people to come and see the submarine docked at the New York City wharfs, and he was passing out leaflets for the same, and he was fined for littering. And somebody told him, perhaps a lawyer, hey, they can't do that to you if you were leafleting for a political issue. Handbills are protected by the First Amendment. So Mr. Christensen, being an enterprising sort, slapped a protest on one side of it, and then he started passing them out again, protesting the wharf charges at the New York, and then on the other side, and by the way, come see my submarine. The court thought, no, you can't get around this stuff by slapping some kind of issue of public concern on your advertisement. We still are not going to cover this. Okay, flash forward to 1976. And we have the court creating a doctrine that it later became known as the commercial speech doctrine. This was a case, Virginia Pharmacy, involved a bunch of consumers who wanted to challenge the Virginia state rule that prohibited pharmacies from price advertising. The state argued that if pharmacies were allowed to argue or to advertise prices of prescription drugs, it would lead to, as lawyers are likely to do, this sort of promiscuous argument about the slippery slope, a decline in professionalism, and that consumers would suffer. And the consumers in Virginia, this consumer group, sued and said, we have a right to hear this information, and the court agreed. And it offered this quote that you have. I just love this, however tasteless and excessive. So we have the commercial speech doctrine, and its justifications, what it provides is that government may regulate commercial speech for its truth, subject to this intermediate scrutiny test for regulation, because the justification for the sort of carving out this exceptional area of protection, not protected, now this little area is protected, truthful speech, is because of listeners' right to receive the information and the public interest in assisting listeners' choices being informed choices. And the court said it's just intolerably paternalistic to say that people like Jack Nicholson, you can't handle the truth, right? That if the truth of prescription drugs of the price was something that we can expect the public to handle, and we shouldn't keep it from them, and the idea that they might do the wrong thing with it. What the law provides, again, is that government may ban or sanction false and misleading commercial speech or speech about an illegal product. If some regulation is challenged, it's subject to intermediate scrutiny, which is a little bit more than just a mere rational basis, but less than strict scrutiny. And so some regulation of truthful commercial speech is also permitted. Totally regulable false speech, some regulation truthful speech. Well, 2 years later, just 2 years later, we have the court being confronted with an election case that the Citizens United majority embraced so closely, which is the Piety decision. And Piety involved a ban, a Massachusetts state ban on referendum, like participation by corporations out of their general treasury funds for issues, referenda that did not affect their business. And the state attorney general of Massachusetts, Mr. Piety, declared that the referendum that was at issue in that case, which was a personal income tax, personal property tax, was not the sort of referendum that would permit corporate spending, First National Bank of Boston disagreed and sought to have that law overturned, and we have this statement. Now, notice what happened here between the commercial speech case, the Virginia Pharmacy, in which we are focusing on the right of the listeners, to Piety, which is arguably not about a commercial speech, although if we had more time, I'd tell you why it is. But is supposedly a case about political speech, is now sort of focused on the content of the speech and the speaker's sort of rights. And the Piety case actually explicitly raised the question that has then since been brooded about and people say about Citizens United, that whether or not a corporation's rights under the First Amendment were coextensive or like parallel to, the same as a natural person. And Justice Powell, writing for the majority, said, oh, no, that's the wrong question. The right question is whether or not this is the type of speech that would be protected. And we find that it is. And then, there was all this language about this sort of the value of the speech does not depend on the identity of its source, setting up some of that sense of that attempts to regulate commercial speech or corporate speech. This arguably was the first corporate speech case, are somehow invidious discrimination. 2 years later, 4 years later, we have a pair of cases, Central Hudson and Con Edison. And these are two really fascinating cases because they both involved regulated utilities, that is, state-granted monopolies. And both cases involved something that they wanted to put in their billing statements to customers, newsletters or something. In Central Hudson, which became the case that decided sort of provided the framework for analyzing commercial speech cases, we have they wanted to talk about the joys or the benefits or promote electrical power. The court treated this as a commercial speech case. It was promoting the thing that it was selling, and it treated it as commercial speech, and it articulated a test. Commercial speech, in order to be classified, now this is incredibly problematic, this definition, but the first prong of the test in Central Hudson is that the speech be about a legal activity and not be misleading, that the regulation in question involve a substantial government interest, that regulation directly advance that interest, and that it do so in a manner that is not more extensive than necessary to serve that interest. Let's compare this to Con Ed. This was a situation in which Con Ed wanted to tout the joys and the benefits and the sort of need nationally for nuclear power. And there was some objection to this, or the law apparently prohibited them from doing this, but this was not treated as a commercial speech issue. This was treated as an issue of what they had a right to talk about, and again, using the Piety formula, is this the kind of speech that we normally protect, rather than what's their interest in speaking. It was analyzed through a more conventional sort of framework of the First Amendment. Both cases, both the Central Hudson and the Con Ed, cited Piety. And what we saw was the integration into the commercial speech doctrine as it's developing of Piety as relevant precedent, which is something that is not necessarily obvious from the development of the doctrine. I mean, you could say, and people have said, well, corporate speech, political speech, like Piety, is something else entirely. And so these are separate doctrines, commercial speech, corporate speech, not relevant. But Piety is repeatedly cited, particularly by those who would like to expand the First Amendment protection to commercial speech. Now let's fast forward to 2003 and Nike versus Caskey, or as it was in the lower court, Caskey versus Nike. You are undoubtedly aware that Nike has been criticized and was criticized for a long time on its labor practices. And Caskey, a citizen of California, used what was at that time, it's since been changed, but at that time, a provision of the California False Advertising and Unfair Trade Practices Act to sue as a private attorneys general Nike for a variety of its statements, most of which were made in letters to athletic directors and letters to the editor and big things on their website and so forth about how we pay a living wage. And Caskey said that wasn't true. And that the reason that they said all that stuff was because they wanted to sell more sneakers, and not because they wanted to participate in a debate on globalization. So count one was violation of unlawful business practices. There's the statute. Count two was predicated on violations of some other parts of the statute, some other statutes, which included fraud and deceit. All you, I'm sure, are really familiar that fraud and deceit are intentional torts, and they are not just about negligent misrepresentation. And then unfair business practices and the violation of California Business and Professional Code. Nike's response? A demur. Your claim is barred by the First Amendment. And I'll just think about what that means here for a second. A cause of action for fraud cannot proceed to discovery because the First Amendment is a complete defense to your claim for fraud. That's a pretty robust kind of argument. And you would think that it wouldn't have gotten very far, but it did get pretty far. This trial court agreed. The appellate court in California agreed. The California Supreme Court reversed using a Supreme Court case, Young's Drugs, and crafting a test that says, well, you know, not all of this speech, even though it appeared in op-eds and in some of these more traditional political speech formats, not all of it seems to me to be political. Some of it looks like it's commercial, and if it's commercial, it's testable for its truth. And so if you said something knowingly, intentionally, that you knew was false, and there was a lot of evidence that they did, then it could sustain its claim. So we're going to let this go forward into discovery. They appealed to the Supreme Court. The Supreme Court put the case on the docket to hear. They heard oral argument. And then, to many people's dismay, they dismissed the case as improvidently granted. But in both the concurring and dissenting opinions to that dismissal and in the questions from the bench during the oral argument, it seemed fairly clear that at least some of the members of the court at that time, back in 2003, were very sympathetic to Nike's arguments that it was simply trying to defend itself, that this was participation in a matter of public concern, and that regulation or testing this speech for its truth would have a chilling effect on saying things like corporate social responsibility reporting and the like. But nothing happened. All right, that case also involved some citations to Bilotti and, you know, the proposition that we have seen already, this sort of idea of invidious discrimination. And my point about Citizens United is I think Citizens United is likely to be used the same way. That is, these very strong statements that that treat the corporation in that context and any corporation as a legitimate participant in these sort of political discussions is likely to be used in the commercial speech context to say that this speech is just as valuable on content grounds. Like, this is just valuable too. This is part of what Virginia Pharmacy said, you know, that it was really important for people's economic decisions. This is not just speculative on my part. I mean, whether or not it takes hold and it really represents the threat that I articulated in the Michigan piece remains to be seen. But whether or not it will be used that way is not speculative. There was a case pending that mercifully now has been, the cert was denied, the massive, giganto conspiracy against the RICO conspiracy case against the tobacco companies, which was pending Philip Morris, U.S. versus et al. Versus United States. That was pending before the court, and in those, the petitions for cert and the amicus petitions, we have the Washington Legal Foundation and the National Association of Manufacturers arguing that the speech on which the defendants were prosecuted, that is, the alleged conspiracy to keep from the public the health consequences of smoking, the illegal marketing of tobacco to minors and so forth, all of these things were protected speech. And, they shouldn't have been the basis of a prosecution, fully protected. And it signals to the court, hey, now's the time that you can decide the question that was presented in Nike and which you didn't decide. And it cited Citizens United. As I say, thankfully, cert was denied on that. And British American Tobacco had another wrinkle in their claim saying, this extraterritorial reach of RICO, that case was also recently, petition for rehearing was denied, so I'm sure they're very disappointed about that. That case is over, but there are other cases percolating up from sort of the grassroots, as it were, of the district courts that raise the same kind of issues and which the same kind of arguments are being made. One of them is Commonwealth Brands versus FDA. This is a court decision out of the Eastern District of Kentucky, Bowling Green Division. And in that case, the tobacco companies and some retailers challenged the recent passage of the Family Smoking Prevention and Tobacco Control Act, which gives the FDA supervisory and regulatory authority over tobacco, including marketing, as unconstitutional, particularly the marketing provisions as a violation of the First Amendment of the Constitution. And the judge agreed with them with respect to some portions of it, portions relating to coloring of packages and any suggestion that because it's regulated by the FDA, that it's somehow an endorsement that the FDA says it's safe to smoke and so forth. And it's not clear how this is going to interact with the remedies that were entered against the tobacco companies in the previous case, because some of them prohibited things like advertising light cigarettes as suggesting that they were safer when they're not. But again, this is not a speculative concern. I want to make sure that I leave some time for questions, and I know we only have about 10 minutes, but I want to say, this is a really, as I said, a little obscure area. It's tempting to think that it doesn't involve very much that would be of concern, especially when you think of it, you frame it in your mind as about advertising, you think, like the Virginia pharmacy majority. It's a lot excessive, distasteful sometimes, but hey, it's free market, right? And it's easy to pigeonhole this into conservative, liberal, and so forth. Here's a quote that I want to offer to you. I remain of the view that the court unlocked a Pandora's box when it elevated commercial speech to the level of traditional political speech by according it First Amendment protection in Virginia pharmacy. In a democracy, the economic is subordinate to the political, a lesson that our ancestors learned long ago and that our descendants will undoubtedly have to relearn many years hence. Who do you think said that? Maybe the recently retired Justice Stevens, who vented his disapproval of the majority opinion in Citizens United with a 90-some-odd page dissent? Nope. Maybe Justice Brennan or Marshall or one of those other liberal icons. No, it was that liberal icon, Justice Rehnquist, from his dissent in Central Hudson in 1980. And he, moreover, said that he thought that the line between commercial and non-commercial speech as set up by the court in these cases was too fuzzy. Justice Powell, who was the author of both the Con Ed, the Bilotti, and the Central Hudson case, and who had been corporate counsel for many years and had authored a memo sort of instructing corporate America right before he came on the bench of how to change their image, engage in more strategic litigation and PR and so forth. ironically, Justice Powell, perhaps because he did have business experience, was very interested in policing that boundary about the so-called common sense distinction between commercial speech and other speech, because he did not want to suggest that you couldn't regulate false commercial speech. In fact, footnote 24 in Virginia Pharmacy drops a really long footnote about why it's not so horrible to regulate commercial speech as it would be to regulate speech generally, because it's hardier than other types of speech, and the speaker has more knowledge about the truth of what they say, and that besides, the government has a legitimate interest in seeing that the stream of commerce runs clearly, as well as just runs. So he wasn't convinced about this, and he argued that the framers never contemplated that the speech of a seller hawking his wares was of equal significance to political speech. To so hold, he argued in that dissent, was to revive the discredited Lochner doctrine and to, cue big music, imperil the government's ability to regulate commerce. So once again, I say, if you cannot regulate commercial speech, it is quite challenging to regulate commerce, since most everything about commerce can be reframed as speech. Now, there are a number of things. I said you might be tempted to think, well, this is just trivial. Who cares about some of this? It's just about advertising. Well, the Citizens United and the sort of offshoots of the effect that this had on legitimizing corporate participation in the political sector, I would think, speak for itself. That's enough of the reason for why there might be some problems here in kind of this, some of this conception. But if we go to what is the core speech of a for-profit organization, that is commercial speech, since that's the core by statute, the purpose of a for-profit corporation is to, engage in business. Protection for commercial speech imperils a number of things. Regulation, as we've seen, of tobacco, alcohol, any legalized drugs. Regulations of product claims, like environmental claims, organic, cruelty-free, sweatshop-free, that sort of thing. It represents an obstacle to being able to verify those things, and those labels are not going to perform the signaling function that economists would say help drive consumer decision-making that help solve our environmental problems, say. This is why we can't solve that problem with consumer decisions alone. But it is a really big obstacle to even whatever moderate solution that consumer decisions can offer, because if consumers can't verify that information, it's no good. Regulation of marketing of pharmaceutical drugs for off-label uses. There are a number of pharmaceutical companies that have paid large criminal fines for marketing efforts of pharmaceutical drugs for off-label uses. They have raised First Amendment defenses in response to those prosecutions. They have not yet, so far, been successful. Claims about securities, so initial public offerings or anything about securities. Claims against the bond rating agencies in our most spectacular meltdown since, the Great Depression. People sued Moody's, Standard & Poor, and one of the things that was launched in defense of these ratings, their opinion, and protected under the First Amendment. Pending multi-agency efforts, and this is why I was talking to the Federal Trade Commission, which in conjunction with several other agencies is looking at ways to try to restrain marketing to children, and I mean children. So whatever kinds of arguments you have about the rational adult who can resist advertising, or, this is apparently not going to apply to children, but the marketing of sugary cereals, fast food, soda, regulation of promotion of financial products, credit cards, and as it most basic maybe suggests, maybe even fraud itself.